Okay, good morning, everyone. We're going to go ahead and get started on our paid family and medical leave webinar. I am Julia Gorton. I'm the State Director of Government Affairs for the Washington Hospitality Association. And we are joined by Matt Buelow, who's the Rules and Policy Manager for the Paid Family Leave Program at Employment Security. Welcome, Matt. I believe we unmuted you. If you could just say hello and if there's any other information you want the rest of the group to know.
Wonderful. Thanks for having me, Julia. Yep, I'm here. Hopefully everyone can hear me and I'm unmuted. But yeah, I'm excited to be here and to help everyone understand what's coming up and how it might help your businesses. So thanks for having me.
Wonderful. So I'm going to start this presentation with a disclaimer. I am not an attorney. So I have worked on the paid family medical leave legislation, worked on that through passage, and then I also sit on the paid family medical leave advisory committee. And so my expertise comes into the area of the actual policy and then implementation so far. So this is a high-level overview of the paid family and medical leave program that will begin January 1st, 2019. This is a lot of information we're going to be presenting to you, so I wanted to make sure that you all knew the additional opportunities to sort of let this information sink in and then go on and get additional information from other resources. In October, we'll have regional meetings across the state. We'll also be joined by the Employment Security Department. The Washington Hospitality Convention this year is November 11th through the 13th. The final day of the convention, we'll have a paid family leave panel with HR attorney Catherine Morissette. The panel on the 13th is free for members. So if you get through today in October and have additional, more detailed questions that an attorney might need to answer, we've prepared that for you all. And then we'll have a final wrap up, combine all of the questions we've received over the past several months, and make sure that we have a more in-depth webinar in December. And then, of course, Matt is in charge of all of the many materials and collateral that the Employment Security Department has, as well as they've got an engagement website that is listed there on the bottom of the screen. Any other important resources we need to touch on, Matt?
Sure. I'd like to let everyone know that we have now hired our first team for the customer care team, who will be looking at claims, voluntary plans, those sorts of things, which we'll talk about in more detail here, and can also be reached by phone, which is not on this slide. And I'll say that phone number a couple of times slowly, so if anyone's interested in making calls, they can. It's 1-833-717-2273, 833-717-2273.
All right, thank you, Matt. And then we do have nearly 200 folks registered for this webinar, which is why we've done our best to mute everyone. If you have logged in through your computer, you'll need to mute on your end so that we don't get any background noise. But we did think with this many individuals, it'd be best if we utilized the chat function. And we're gonna go ahead and move on. So the law, as I mentioned, the law takes effect January 1st, 2019. Premiums begin January 2019. And if you get nothing else out of this presentation, the most important thing you take away from today is that the premiums begin the 1st of this year. The benefit program for employees being able to access the leave will begin January 1st, 2020. And every employer, regardless of size, will have new requirements, and we will go over those now. So first, I mentioned beginning January 1st, 2019, this applies to all employers. There are almost zero exemptions to this program. While there might be exemptions to pieces of the program, this does include all employers and all employees. You'll see an asterisk there at the end of that first bullet point. There are some differences for employees in a collective bargaining agreement. Those folks still need to, are still applied to this program. However, if you do have a CBA, you're grandfathered into the program, which means when that agreement ends, you will be subject to this program. But until that time, the employer is not required and the employees do not have access to the program. There's also option for a voluntary plan. So if you're a business that already has a paid family leave program, we'll go into that a little bit later. And then it doesn't apply to employees who don't perform localized work in Washington. So for example, if your business and your employee is located on a border town, maybe in Oregon or Idaho, and from time to time they may need to come into Washington to perform work, as long as they're under the hours threshold, it doesn't apply to them. But with those very small exemptions, it applies to all employers and all employees. So employers must collect premiums starting January 1st. That's on all wages up to the Social Security wage base. And wages in this instance do not include tips. So you'll be collecting premiums from all wages minus the tips. That is a distinction from current unemployment insurance. So there's that small difference there. And then beginning January 1st, 2019, all employers also have to report wages and hours to ESD, similar to how you report unemployment insurance, and wages do not include tips. Matt, I believe ESD is still sort of setting up the technical side of how employers will report wages, but is there anything that employers need to know now?
Sure. Yeah, we are still creating the technological solution because of the tight legislative deadlines. You know, we're doing it in a very iterative approach. So I can't give you 100% details, technical specs, anything like that, but we are putting together an online portal for employers to access and do reporting. Our hope is that we create the electronic means to do so, and that, I mean, our goal is to get 100% of employers to file electronically. We know that there, for various reasons, that may not happen, so we will have alternate methods available as well, probably a paper process, that sort of thing. But we will absolutely be communicating that as it's developed with more detail.
Great, thank you. And then beginning January 1st, 2020, all employers have a notification requirement to their employees, updating the info on the labor poster. All of Hospitality Association members receive that poster from us. So good news there is if you are a member with us, that requirement will be taken care of. You can check that off the list now. And then any employee who has been absent for reasons under paid family leave have to receive a written notice of their rights and ability to take this leave. That will simply just be a form that's developed by the Employment Security Department. If you have an employee who has a major medical issue or whatnot, you just shoot that off to them. That, of course, is being developed. Am I missing anything on that that piece, Matt?
The only thing I would add there is the requirement to notify employers is triggered by two things. One, you have to sort of know why the person's on leave, so you don't necessarily have to notify anyone who's just absent, and it doesn't trigger until someone has missed 7 consecutive days of work. So you don't need to do it if someone's only missed 1 or 2 days.
Great, thank you. All right, now we're going to get into the summary of the law. This is a broad-based insurance program that's overseen and administered by the Employment Security Department that does works, kind of functions similarly to how the unemployment insurance system works, which is why ESD is overseeing this program, because they've got experience on how managing a program like that works. The overall cost of the program, because this is an insurance program covered by both employers and employees, the total cost is going to be a 0.4% payroll tax the first 2 years, and then afterwards it will be adjusted annually to make sure the fund is solvent. Within the overall paid family leave insurance program, there are 2 separate buckets that are established: the paid family leave bucket as well as the medical fund bucket. The family leave fund is going to be funded entirely by employees, and that makes up about 1/3 of the cost of the overall program. The family leave bucket covers issues like child bonding, having an ill family member, or any issue that's not specifically related to the employee. The medical fund, which makes up approximately 2/3 of the overall cost, is split between the employer and employee. So 55% is paid by the employer and 45% is paid by the employee, and that covers issues related specifically to the employee. So what that means for employers is the total cost of their share of the 0.4% payroll tax is 0.148% of payroll. What that means, if we break that into a couple of examples to kind of determine the cost here is, and we've got examples here at the bottom, if you have an employee who's making minimum wage, working 30 hours a week, that equates to about $27 a year. If you have an employee who is making average wages, which is in Washington is around $60,000 a year, it's going to be about $62 a year. Again, this is just the employer cost. And for every $1 million you have in payroll, it's about a $1,400 cost for the employer for this new program. And the only thing that I guess I would add to this piece is this is the minimum requirements of the program. If an employer would like to pay the employee share or pay the entire 0.4%, they are able to do that, but they have the minimum requirement of the 37% of the 0.4%. Anything extra there, Matt?
No, great job. Thank you.
Okay. So there is a small business exemption. If businesses that have fewer than 50 employees, they're exempt from just the premium cost. They still have requirements like all of the other employers, collecting and remitting the payroll tax for the employees and submitting the wage and hour reports to ESD, but they do not have to pay the employer share of the premium. So important questions are, how do you know, or how are the employees counted? And how do I know if I fit into that small business piece? So what will happen is ESD will determine how many employees you have based on your first quarter reporting for January 1st through March. They'll look at that report that's due April 30th. They'll see how many names you have listed and how many individuals you've reported wages and hours for. And if that number is 50 or more, then you are not considered a small business. Important piece of that as well is that franchisee businesses are counted independently. So we have seen a trend across the rest of the country and in some cities in the state where franchisee businesses are sort of looped into one general business, but ESD is looking at individual legal entity by individual legal entity. So if you pay unemployment insurance to the department now, it's going to be based on how you do that currently. And then beginning September 30th, 2019, ESD will determine employee count based on the average of 4 quarters. So that should adjust for the seasonal nature of our industry as well as any other seasonal industry. Did I get that right, Matt?
Absolutely. The only caveat that I would throw out there is for the first bullet point for how we will determine employees for the first quarter. That is true that is currently our proposal in our proposed WAC regulation rule that's out for comment. It is not yet final, so it could potentially change depending on the feedback that we receive on that rule, but that is our current proposal.
Great, thank you. I'm going to pause here and go to our chat box and see if we had any questions arise.
I don't remember. I don't remember what it was.
All right, it looks like we have a question, Matt. Your assistance on this question will probably be needed. Regarding the employee count, will it include persons employed simultaneously or counting turnover as well? And I believe, Matt, I have asked for clarity on this, and I will repeat what I believe I heard, I've heard you say before.
Certainly.
You're looking at the total number of employees who have been employed during a quarter. So if you have an employee that is hired and they work half of that quarter, that employee either resigns or is terminated, and you hire a new person to replace that person, it's still another name on the report you're submitting. So it doesn't account for, we're not talking about position, we're talking about number of people.
That is correct.
Okay. Let's see, I think we're up to, will we receive a copy of the PowerPoint? Yes, this will be available on our website for download. You can send it around to any team members you have, or you can watch it as many times as you as you would like. Okay. So there are a number of business incentives that were included in this program. And the first one is a little bit unique to Washington. Our unemployment insurance is unique in that it is rated based on experience. So the more individuals or employees that you lay off, the higher unemployment insurance rates that you pay. So creating a new benefit program for employees who leave, where you may need to hire a temporary employee, could have impacted unemployment insurance charges if you have a temporary employee that you then lay off when your permanent employee comes back from leave. So this was a really important thing that we wanted to make sure we corrected. So all employers who are impacted by this program or have an employee who leaves to take advantage of paid family leave, if there is a temporary employee hired, you will not be charged on your UI rates for that temporary employee being laid off when the individual comes back from paid family leave. So that is a new benefit that is not current, that businesses will have access to once this program kicks off next year. And then for businesses who have 150 or fewer employees, and any business that is exempt from the program but exempt from paying the premiums but chooses to opt in, are eligible for a $3,000 grant should they have an employee who leaves to take this benefit and they need to hire someone. So you have an employee who is irreplaceable, who is performing duties that you just cannot simply cover by increasing hours of other employees or having someone cover for that person, and you need to hire someone. The $3,000 is to cover the cost of placing an ad, time it takes to interview an employee, the cost to train, and anything related to that. If you don't need to hire someone, but you plan on covering that employee's duties through current staffing, or overtime costs, if you track the costs related to that, either through payroll, then you can submit those costs and get reimbursed for up to $1,000 if you have someone an employee who leaves to use the benefit. And then there was one final issue addressed in this law. This was brought up by larger employers, but this is available to any employer who has a current program. There were a couple of employers who had very popular paid family leave programs already in place and were concerned that switching over to a new system would be an employee retention issue. So there does exist a waiver for businesses who already have a program that meets the benefits of the state program. Again, we're going to talk about this in detail. All right. So what employees are eligible for this new program? This will apply to all employees who worked in the workforce for 820 hours, regardless of whether or not they've worked for you for 820 hours or worked for you for 400 hours and another employer for 420 hours. So it's really an hours threshold that qualifies employees for this. 820 hours is about 5 months at full time or 15 hours a week for a full year. Employees who work for an employer with fewer than 50 employees, so that that business is not required to pay the employer premiums, they're still covered by this program and they still pay into the fund. The only difference is that the employer is not required to pay the employer premiums. Independent contractors and self-employed also have an option to opt in. And then of course, there is a difference, right? Because an employee may be eligible to take the leave, but again, they're only taking the leave if a qualifying event has occurred. There will be medical certification, and then they send that medical certification to ESD, and ESD reviews and approves or denies the claim if they meet the requirements. How am I doing, Matt? Have I missed any detail?
No, you're doing perfectly.
Great. All right, so what is a qualifying event? This really covers sort of blessings to tragedies, as we've identified. We tried as best we could to have alignment here with FMLA, with the Federal Medical Leave Act. And again, these events have to be medically certified. So they include birth, adoption, placement of a child, not only for the mother, but also the father, a serious illness of a family member that requires treatment or care. And that's those family members are identified as a parent or a parent-in-law, grandparent, spouse, sibling, child, or grandchild. And then military exigency, which is also a covered issue under FMLA. It also covers any serious medical issue related to the employee. So I think this might be a good time too, Matt, to emphasize that an employee, let's say an employee has one of these issues, they file a claim, the employer's notified, the employer will have the opportunity to appeal that decision. So let's say, for example, you have an employee who indicates that their grandmother is sick, and you say, wow, you have a lot of grandmothers. This is the sixth grandparent you've told me about. The employer does have an appeal process that they can utilize. Is that correct?
That is absolutely correct. And even I'd take it even one step further. We will notify an employer when a claim is filed, and the employer will have the ability to give us that information for consideration into the determination before an appeal is even necessary. And then depending on the outcome that we decide, either party can appeal the decision.
Great. I see we're getting a couple of questions about how family members are defined. I'm going to go through those quickly. Okay. How do we know if an employee, that's an hours question. I assume step-parent will be covered under parent for purposes of the benefit. I don't believe step-parent is. Parent and parent-in-law.
I'm bringing up the statute in front of me before I misspeak.
Why wouldn't it be?
I believe it is covered. I just want to validate that. So the definition of parent in the statute, let me scroll. I'm doing this on another phone, so pardon the delay. So parent is biological, adoptive, de facto, or foster parent, step parent, or legal guardian of an employee or the employee's spouse, or someone who stood in loco parentis over the employee when the employee was a child, which is a very legal term of art, by the way.
Okay, great. So it does include step parent. Thank you for that.
It does.
All right. We do have a question about, does this run concurrently with FMLA? The answer is yes. Okay, so length of the benefit. Employees who are eligible and have a qualifying event do have access to 12 weeks of family care. I'm going to, I guess, pause and step back. Again, remember there are two separate buckets in this insurance pool. There's the family care bucket and the disability bucket. They're eligible for 12 weeks of leave. In very rare circumstances, an employee will have two issues that could be from both buckets. I think probably the most common incidence of this would be an employee who is pregnant and has the family care issue, right, for when the child is born, they get the family bonding time. And then they also have a medical issue related to the pregnancy. So in that situation, an employee, and this is a very limited situation, an employee would be eligible for a total of 18 weeks. Again, if they have a disability related to the pregnancy, as determined by a medical professional, and then they have the 12 weeks to bond with the child. So a maximum of 18 weeks in that limited situation. At the end of this program, we're gonna go through a couple of examples of how this would work, and we can talk through in detail about that. I did actually have, I had a couple of complicated questions about leave. And the only situation where an employee is automatically eligible for 12 weeks is with the birth, placement, or adoption of a child. If someone has an accident, an injury, let's say they break a leg or something like that, a medical professional would be evaluating how long the recovery time is and would issue, right, I think this person needs 6 weeks of recovery. It wouldn't automatically be a 12-week leave unless it's for bonding with a child. Have I gotten that detail correct, Matt?
Absolutely.
So job retention benefit. We worked really hard to make sure that we were not creating a new requirement or new liability for employers related to keeping a position open for employees if they use this benefit. So we worked to have FMLA alignment to the best that we could. So the job retention benefit aligns with the current FMLA law almost. And I'll say the one difference is that an employee is eligible for the job retention benefit if their employer is recovered under FMLA, which means the employee has worked there for 1,250 hours in the last 12 months, and they have 50 employees within a 75-mile radius. In our state law, the 75-mile radius has been removed. So if you have an employee who has worked with you for 1,250 hours over the last 12 months, and you have more than 50 and you have 50 or more employees, then they do have the benefit of having their position held for them while they're out on paid family leave. Again, this runs concurrent to FMLA, so they get their state benefit of the paid family medical leave, and that runs concurrent with FMLA. So there's not two separate leave benefits for the employee. Okay, so now I'm gonna get into, actually I'm gonna take this moment to check questions. We have quite a few questions. I'm gonna see if I can go up to where we left off. We do have a question about eligibility. Yes, ESD is responsible for tracking eligibility and hours, and they will know whether or not an employee is qualified. So that is not the employer's obligation. It does run concurrent with FMLA. All right, a pre-existing medical condition, disabilities included. So I guess if someone had a previous injury, I'm trying to figure out how to answer this question. It doesn't matter if an employee was injured or had an issue before they came into employment or not. This benefit is for employees who have a medical issue and they receive medical certification from a doctor or a medical professional. I might need a little help, I guess, understanding the question so I can answer that better. And then where would a domestic partnership fall under? A registered domestic partnership is considered, they would be considered a spouse. Correct, Matt?
Correct.
Does it cover siblings in law? Matt, you might have to read the statute again.
It does.
Okay, it does include siblings in law. Does Washington leave run concurrent? Yes. And I think that brings us up to speed on the questions we've received so far. Great. Okay, summary of the law, wage replacement. I have left this slide up while I answered questions, and this probably provided a lot of stress for those of you who are looking at this right now. What I want to say is that it is not the employer's obligation to determine this amount. This is entirely the responsibility of Matt and his team to figure out the wage replacement. I did want you all to know how it works, though, so that's why we're going over this. You can, decide whether or not you want to become an expert in this piece of the policy or not. But while employees are out on paid family leave, they receive a portion of their wages, and it is a complicated calculation because the drafters and sponsors of this legislation wanted to make sure that it was a progressive wage replacement, meaning individuals who receive lower wages are able to get more of their salary than individuals who earn more and may not need all of their salary to make ends meet. So that is what we've ended up with. So 90% of wages, up to 50% of the state's average weekly wage. The average weekly wage is determined every year, so that's based on the average wages across the state. Currently, that number is $1,100 a week. So employees who make $595 a week or less, again, not including tips for our employee, receive 90% of their wages while they're out on paid family leave. For folks who receive or who earn more than 50% of the average weekly wage, it's a two-part calculation. So they receive the 90% of the 50% of the average weekly wage, and then 50% of their wages above that number. For higher earners, no one will receive a benefit more than 90% of the average weekly wage, or $1,000 for the first year of the program, and then that's adjusted annually after that. And so I have an example here at the bottom of the screen, so you can see how the calculation works out. And that cutoff works for employees who earn more than $79,000 a year. Again, this is the Employment Security Department's calculation to make. The employer has no involvement in this part. Okay. So you may have questions about what is the difference between paid family and medical leave and paid sick and safe leave. Both are now requirements, or will be requirements, for employers moving forward. And I think for us, a big difference between the two programs is the paid sick and safe leave piece that's already that took effect January 1st, 2018, was part of the minimum wage initiative. That policy was developed by initiative, whereas the paid family and medical leave program was a result of legislative compromise. The Department of Labor and Industries oversees paid sick and safe leave. They also oversee the minimum wage and wage and hour laws, whereas ESD, who oversees the unemployment insurance program, will oversee the new paid family and medical leave law. Who pays for the leave is different. Again, paid family and medical leave is a broad insurance pool, whereas the employer is paying for the employee's paid sick and safe days, 100% of their salary. Who determines eligibility is different. An employee who is eligible for paid family leave has to get medical certification, so they have an issue that's medically documented by a professional then ESD reviews that claim and then either approves or denies that claim. Whereas with paid sick and safe leave, right, it's an employee, and then you can only request verification of that after 3 days of absence. The leave is different. So paid sick and safe leave is really for less serious issues, cold, child being sick, needing to stay home from school, whereas paid family and medical leave is for long periods of absence because of very serious medical issues or because of bonding with a newborn or new child. The amount is different, right? You get 100% of your wage on paid sick and safe leave, whereas the paid family and medical leave is a portion of your wages. And then there is some crossover with the use of paid sick and safe leave and paid family and medical leave. And then an important distinction or important point to this program as well is that employees cannot be receiving the same benefit at the same time. So you are either using paid sick and safe leave or paid family and medical leave, but not both. Okay, so now we're going to get into a couple of examples. I have 4 examples we'll go over. And then let's see here. I'm going to pause and look at questions one more time. Would the employer still continue to pay sick, vacation as according to their policy, even if employee is receiving this benefit? And the answer to, again, not being an attorney, so not knowing how your employee manual or what your program is or stipulates, the employer is not required to pay sick and vacation on top of paid family and medical leave. In fact, Matt, correct me if I'm wrong, but in fact, it's not allowed for an employee to take paid sick and safe leave and paid family leave.
Not for the same period of time, that's correct.
Are these benefits paid to the employee directly from the state? Yes. Every employer who is in the state program, meaning they don't have a voluntary program, the employee is receiving a check directly from the Employment Security Department and not from you. Will ESD provide paid family and medical leave benefits to an employee if the employee is also receiving short-term disability or long-term disability benefits through their employer or any form of paid time off during their leave? How will this be determined? That is a good question. So I'm assuming that this question is regarding an employer-provided short-term disability program or long-term disability program. In that situation, Matt, would an employer indicate to the agency if they got a claim that the employee is receiving a short-term disability benefit?
So I'm going to answer this a couple of different ways. And honestly, part of my answer is going to be we're still working out the details. So as we continue down our rulemaking efforts, one of the things that we have not yet started is how does this benefit play with other, how does it interplay with other paid leave benefits? So we still don't know a lot, and we will have more forthcoming throughout 2019 before we start making benefit payments in 2020. But our current read of the law is that short-term and long-term disability payments probably would not impact someone's ability to receive this benefit because it doesn't constitute a quote-unquote wage that the law requires for us to deduct. The second part of that question that I heard was other paid time off. And that's where it gets a little bit more gray because it depends on what that pay is and what it's for. But generally speaking, as Julia answered in an earlier question, someone will not be able to receive vacation or sick pay for the same time they're receiving paid family and medical leave. Actually, I should say that the other way around. They won't be able to receive paid family and medical leave for a period of time they're receiving, vacation or sick or PTO, whatever, how the company does that. So likely they would be able to receive disability payments from an insurance policy because it doesn't constitute a wage, but not paid time off because it does constitute a wage. With all of that said, the big caveat is we haven't started that rulemaking yet, so I don't know how it will come out in the end, but that's our current read of the statute.
All right, thank you. All right, we have a couple of other questions I think will be answered if we go through these different scenarios here. So I'll start with the first one. A small business, so they have fewer than 50 employees. They have made a decision not to opt into the program, so they're not paying the employer share of premiums. This example, we have Jane, who's a qualified employee, so she's worked 820 hours in the workforce, and she's paid her portion of paid family medical leave through a payroll tax. Jane has a very serious accident, and she's able to take 12 weeks off and get the paid family medical leave benefit to pay her bills while she's recovering. While she's out, she gets a check every week from the Employment Security Department. Again, this is a small business, so they just weren't able to make ends meet without that position being covered. So they wish Jane the best, and she gets her benefit from ESD while she's recovering, and they hire a new employee to replace Jane's. Move into the next one. This one I might go into a little bit more detail on. So this is a small business. They have fewer than 50 employees, and they did choose to opt into the program. So June, in this scenario, we have June. She's a qualified employee, so she's worked her hours. Payroll tax has been paid and paid to ESD, and the employer has also paid into the program. So a qualifying event occurs. She's in a very serious accident. She is required to notify her employer as soon as possible. And I believe, Matt, this is still in the rulemaking stages, but the current draft is she has 1 business day to notify her employer. Is that accurate?
Correct.
So she has, there is a reporting requirement back to the employer. She's able, she files her claim with the Employment Security Department. They review it. She's able to take up to 12 weeks of paid family leave, according to whatever her medical documentation says, whatever she needs to recover. And she receives a check from ESD. Because the employer opted into the program and they're under 150 employees, which is that small to medium sized threshold to get this incentive, they apply for a $3,000 grant to cover the cost of hiring a temporary employee while June is out. She's let's say she's a sales manager and they need to keep that position, or someone working in that position, and they just can't make it work while giving other employees additional shifts to cover while she's gone. They have to hire someone. So they get that assistance from the program. And when June returns, when June's healthy, she returns to work, she comes back to work. The employer can either thank that temporary employee for their service, or maybe that employee turned out to be an exceptional team member and they want to keep them on. That is the employer's decision to make at that point. Okay, so here is an example of a larger business. So they have more than 200 employees. In this example, this business is already covered or has the requirements under the federal Family Medical Leave Act. So they have the same requirements with the protected leave of up to 12 weeks, and then the employee retention, holding that position for the employee while they're out. So in this example, we have an employee who is covered under both the state law and the FMLA requirement. So she's worked a full-time employee. She's met the requirements for both of those, both the job retention as well as the state program. She's paid her paid family leave. The employer has paid their share of the paid family medical leave. She has a medical issue, which will be the birth of a child. So she has advance notice of a medical issue. In this situation, she's required to provide at least 30 days notice before planning to give birth, or if it was an individual who had a surgery scheduled that they knew at least 30 days in advance, they'd have to give that notice. But in this situation, she's aware that she's pregnant and that she will need to take leave. She has to give a minimum of 30 days before that event. So she does that. She has a qualifying event. Her doctor says, you have a very serious, complicated pregnancy. You need to be on bed rest. So she then has 1 business day to inform her employer, because that was not a foreseen event. She files her claim with the Employment Security Department. She's on 6 weeks of bed rest. And again, that's taken from the medical leave bucket. Then the baby is born and she takes the 12 weeks that she has for family bonding, for a total of 18 weeks. This is the only scenario in which someone would be eligible for 18 weeks of leave if they have both a medical issue as well as a family leave issue. So while she's out on leave, the employer hires a temporary worker and then lays off the temporary worker when she returns from her leave. In this situation, because we included that business incentive, the employer is not charged for the temporary worker's UI experience. So this would be a cost savings in this scenario that doesn't currently exist without the state program in place. All right, this is my last example, and then I am going to move quickly into the voluntary program and how that works. So this is, again, a larger business. This is John. It's his second day on this job, but he's worked 820 hours and in the workforce, so he's qualified for this leave, but he is not qualified for the job retention benefit because he's not a FMLA covered employee. So he has an event, it's his second day on the job, but he's already paid and eligible to take a benefit. So he is able to leave and take care of the issue his spouse is having. He gets, up to 12 weeks of paid leave to help his family member recover. The employer in this situation is not obligated to hold a position or continue health benefits for John because he did not work more than 1,250 hours in a 12-month period. So that's sort of how this aligns with FMLA. There's not an additional requirement if the employee has not met that 1,250 hours in 12 months. Okay, so I'm going to move into the voluntary plan. If there are individuals on this call who think, who already have a paid family medical leave program or think that they might be interested in this, we'll get into how that works. I'm going to stop here and look for questions. Okay, if the employee is confused and files for unemployment as well as paid family medical leave, will ESP catch that and duplicate payments? Matt, do you know if your system?
I was going to say, I assume you want me to take that one. So the law has a prohibition of an employee receiving unemployment insurance and paid family and medical leave at the same time. And by the way, also workers' compensation. So we, operating 2 of those programs will make sure that we are in sync with the other divisions and have our computer systems working in tandem to prevent duplicate payments from both programs. In fact, the requirements to qualify are vastly different. So someone could not conceivably qualify for one and the other, just because one requires that someone be able and available for work, which is unemployment insurance, paid family and medical leave. By definition, the person is out of the workforce for temporarily. And then the same thing is true with workers' compensation. So we will have a data sharing agreement with labor and industries like we already do for our unemployment insurance, and we'll be doing cross matches to make sure that people are not receiving both benefits, and when they are, we'll assess overpayments and or fraud as necessary if there's any fraudulent behavior.
Great, thank you.
Mhm.
What if the employee is not able to notify the business after 24 hours? If they're in a coma, can someone else notify the employer? So the law requires that the employee notify the employer as soon as possible. If they're in a coma, then I would assume, Matt, the department would interpret that as it's not possible for them to notify the employer. Is that's correct?
Yeah, so these are also in our draft rules. So again, not final, but kind of our current thinking, there's sort of two kind of buckets for notification. There's the foreseeable leave, someone who, is scheduling surgery for something, months in advance, where it's not preventing them from working yet, but they're going to need some downtime, for example. The law actually requires a 30-day notification when it's a foreseeable event. If the foreseeability is less than 30 days, then what the law says is as soon as is practicable. And for unforeseeable leave, in our current draft rules, we are applying the same as soon as is practicable sort of concept. So depending on the individual circumstances will depend on what that notice requirement is. We are, in our current draft rules, also allowing someone else to provide that notification to the employer, that it doesn't have to be the employee themselves, like in the case of a coma or something along those lines. The other thing that I will throw out there about notification is the law does require that notification be in writing. So a phone call won't suffice. They'll have to do something in writing, and we're working through what that looks like in our draft rules right now as well.
Great. And then let's say this individual is in a coma. Does the law allow for someone related to that employee to fill out a benefit claim on their behalf?
So the law itself is silent on that, and that is something that we are internally discussing now about what that might look like and how that could work. We don't have any rules out for comment around that yet, but we are internally working through that process. So stay tuned, and we'll be providing more information in the next couple months around that.
Great. But I do, if the department did receive a claim, they would notify the employer. So the employer would get that information one way or another.
Absolutely.
Who administers the grant process? Can you hire on your own, or will you need to hire through someone else to receive the grant? That's a really good question. And to answer that quickly, we don't have that worked out yet. And this benefit will take place January 1st, 2020. And Matt, correct me if I'm wrong, but what we've kind of discussed is that you have an employee who has left unpaid family leave. The department has recognized that, so they know that there's someone gone. When you hire someone, you would fill out a form of some type that has that employee's information on it and say, this person is hired to replace this. So there would be some sort of tracking to identify that employee.
There was a little bit of background noise, so I didn't quite hear everything that you said. I didn't quite hear it. I'm sorry, we're having a fire drill. I'm at the same time that I'm trying to have this conversation. So I have someone blowing a whistle at me. I couldn't quite hear everything that you said, Julia, unfortunately, but everything that I did hear was absolutely spot on. So
great. But just to summarize, that those details will be forthcoming later because the benefit program doesn't actually start until January 1st, 2020, but we'll definitely keep information available and about how that would work.
Yeah. One thing that I can say unequivocally about that, however, and you may have said this in the part I didn't hear, is there won't be a requirement that someone uses a specific agency or entity to do the hiring in order to have access to that grant. You will be able to do your own hiring and still apply for those grants. That I can say.
Okay, so in Maria's scenario, the 14 months worked, does that need to be with the current company or just an employer in Washington? It would need, in order to get the job retention benefit, it has to be with the same employer. The employer is only required to hold positions for employees if they have worked with that employer for the certain amount of time, and that employer has more than 50 employees. Okay, we are running a little bit over. I'm going to switch into the voluntary plan waiver and walk through quickly how that works. And then we'll come back and answer questions if we have more time. I want to be respectful of everyone's time, and I know we were a little slow getting started here. So the voluntary plan waiver is for a company who offers their own paid family and medical leave package that meets the requirements of the state requirement. So a voluntary plan, you can receive a waiver if you have a plan that either meets for the family leave benefit or for the medical leave benefit, or you could apply for a waiver if you have a program that meets both of those. Voluntary plans could be administered through a third party. So if you already have a robust short-term disability leave program or long-term disability program, and you want to maintain that because your employees really like that, or for whatever reason, it's a program that you use across the country, as long as it meets the benefits of the state program, you can continue to use that and apply for a waiver from the Employment Security Department. Thanks. So there's a couple of differences in requirements if you want to receive a waiver. For example, if you seek a waiver and have a voluntary program, you have higher requirements regarding the hours worked for the job retention requirement. It's 9 months at 965 hours to receive when employees receive that job retention benefit, versus the state plan, which is aligns with FMLA, which is 12 months, 1,250 hours. There's a difference in hours threshold, so the employee has to work for you for only 340 hours in order to receive your voluntary plan benefit, versus the state plan, they have to be in the workforce for 820 hours. They still have the same amount of protected leave, and this is an important distinction. They have the 12 weeks and 12 weeks for a total of 18, the same as the state plan. However, for the paid leave benefit in the voluntary plan, you can provide paid leave for half the amount of time on the state plan, but the amount of payment your employees are receiving while they're on leave have to be equal to or better than what they would have received in the state plan. So we'll get into a little bit how this works, but why you might want to consider a voluntary plan. It could be more desirable for employees if you already provide a greater amount of salary replacement while they're gone. Again, the salary replacement in the state plan is just a portion of their wages, where, perhaps you provide the full salary replacement in your voluntary plan that might be more attractive to your employees. And it's also could possibly be more attractive to you as the employer because it could allow for an incentive for your employees to come back to work sooner. So here's an example. We have Sean. He's worked 40 hours a week for 10 months. So he is eligible under the voluntary plan for the job retention benefit. But if he were working for an employer who is in the state system, they would not be eligible for the job retention benefit. So there's a higher threshold here for someone who has a voluntary plan. He's paid his share of the paid family leave through his employer, and the employer already provides a short-term disability insurance program. So they got a waiver from the state program for their medical leave fund. So there, and again, we have a lot of car accidents in our scenarios. So these are some unfortunate individuals here. So he has a qualifying event and he's unable to work. The voluntary plan waiver that they have, they've got a short-term disability program where he receives 100% of his salary while he's gone. They've crunched the numbers and that is equal to or more than what he would have gotten on the state program. But his employer's program only provides for 7 weeks of leave, which is allowed under the law. But he still has the protected leave, right? So he can be gone for more than 7 weeks. It's just not paid. So he still needs one more week. He needs a total of 8 weeks, and his plan only provides for 7 weeks at full compensation. So good for him that he still has 40 hours of paid sick and safe leave. So in this example, he just uses that to cover his final week while he's gone. If he didn't have 40 hours of paid sick and safe leave, he just simply wouldn't get the compensation for that week. But this is really how the voluntary program is designed to work. If you have your own plan that meets or exceeds the state requirements in this area. This is a very brief overview of how a voluntary plan works. If you are interested in learning more about this, I would just simply ask that you reach out to myself or to Matt or Matt's team and get more information. But I wanted to make sure that those of you on this webinar knew that this is an option available.
I'd like to just jump in and just provide 2 little small minor pieces of clarification around voluntary plans. And I know it's a really high level overview, so I won't dive into the weeds. But on the 340-hour requirement, I just want to clarify there that the requirement under the law for 340 hours is that anyone who works for you less than 340 hours, you do not have to put into your voluntary plan. They can stay under the state plan, but once they've worked for you for 340 hours, they have to be covered by the voluntary plan, but you don't have to pay benefits to someone who's only worked for you for 340 hours. You can still have the 820-hour requirement in order to pay benefits. So that's just a little nuance there. The other point of clarification is regarding the paying half the weeks of benefits. It is allowed under the law. However, the total amount of benefits paid to the individual have to equal what the state would have paid over the entirety of the leave. So for example, if someone would have qualified for the maximum of $1,000 per week for 12 weeks for a total of $12,000, say it's for parental leave, so we know that they could be eligible for the full 12, you could pay them over 6 weeks, but you'd have to pay them $2,000 per week for those 6 weeks for a total of $12,000.
Thank you, Matt. That's an important clarification.
Yep.
Okay, so I wanted to make sure you had both my email address and Matt's email address. This was a lot of information to cover in a short period of time. Again, I think the most important detail you need to take away from this presentation is that beginning January 1st, premiums will need to be collected from employees' wages, at least, at a minimum, employees' wages, possibly the employer portion. So that's sort of the next step for businesses, is to make sure that their payroll systems are set up and in place to meet that requirement beginning January 1st. We will have a number of other opportunities to go over these details in more depth. We also have a number of member benefits available to you all if you need to speak to an HR attorney or need some HR assistance in crafting the right policy or integrating your current policies with the new state requirement. Reach out to us. We can get you in touch with the right people. And there's Matt's email address if you have any questions of the agency or how they will interpret any of the issues we went over. You can reach out to Matt. He'll get you pointed in the right direction. We're about 10 minutes over from what we had committed to you. I think we do have time to, looking at Nicole, I think we do have time to answer some questions. So I'm going to hop on over and see what we've got going on our chat box. Are you pointing out this one? Okay. A normal birth does not qualify for 6 weeks of medical leave. So that would be, as I'm not a medical professional, that would be, I guess, correct. It all depends on what type of medical documentation that employee has received or what her doctor has identified that she needs leave from. Businesses with up to 150 employees have been addressed, and businesses from 200 plus have been addressed. What about businesses between 150 and 200 employees? So once you have more than 150 employees, you're no longer considered a small or medium-sized business. So you aren't eligible for some of those, for either of those $3,000 grant or $1,000 grant, but you still receive the benefit about the unemployment insurance non-charging of laying off a temporary employee. How can the rates be determined at the end of the first quarter when we need to know if we're required to pay the employer portion starting in January? That is a great question. So the employee share of this program would need to come out of every employee's wages beginning January 1st. You can't, if you forget to take that out, you can't go back later and withhold that from employees' paychecks. So that needs to begin immediately January 1st. Both the employee share and the employer share are due, and Matt, jump in here, correct me if I'm wrong, but they're both due at the end of the quarter.
Correct.
Everyone has to pay, or everyone has to collect the premiums from employees. Only the employer share that will need to come at the end of the quarter, or that will need to be paid at the end of the quarter. And did I answer that correctly, Matt? Was that?
You did.
So you may not know whether or not the department has identified you as an employer with more or less than 50 employees, but you don't need to be paying anything until the end of the quarter. So that's how that will work. Last question. Okay, if tips are not included when calculating premium cost and employers will not be reporting tips to ESD, does that mean tips are not included in the benefit calculation when someone is on leave? And that is correct. If you have a service charge system, those would then be considered wages if you use service charges. But tips are not reported and then therefore would not factor into an employee's wage replacement. Okay, so this is again our first attempt on bringing this information out to our members. We'll have a number of other opportunities at our regional meetings across the state in October, as well as our hospitality convention in November. This will be available on our website to download and watch, again, as many times as you would like. And then, of course, we are always available for questions anytime. And actually, Matt, you guys have a pretty robust program where I think you've been invited to a number of different events, speaking events, or HR meetings, or things like that. So for any resource that you may need, or any details any issue you'd like more details on, please reach out to either myself or to Matt.
Absolutely.
All right. Thank you, everyone.